There is a type of tort nowadays referred to as injurious falsehood, which is similar in its general nature to defamation, but with some key differences. Injurious falsehood occurs when someone maliciously publishes imputations about a business with the effect that they reduce the custom of that business. So, whereas defamation protects a person's reputation, injurious falsehood exists to allow a business to recover losses which have been inflicted upon it by another person's malice. In this case, Ratcliff operated an engineering and boiler-making business called Ratcliff and Sons, which he had inherited from his father. For reasons which are not given in the judgment, Evans, who was the proprietor of a newspaper called the Country Herald, included in the paper a story claiming that Ratcliff and Sons had ceased to operate and was no longer trading. Unsurprisingly, Ratcliff and Sons lost customers as a result. The lower court calculated their loss as £120, but Ratcliff and Sons had not alleged or proven the losses from any individual customers who would otherwise have engaged them. They merely alleged a general loss of trade arising from the malicious falsehood. The question before the Court of Appeal was whether this was sufficient. Lord Justice Bowen stated that an action will lie for written or oral falsehoods where they are maliciously published, where they are calculated in the ordinary course of things to produce, and where they do produce actual damage is established in law. On the question of what damage had to be proved, Lord Justice Bowen stated, "As much certainty and particularity must be insisted upon, both in pleading and proof of damage, as is reasonable, having regard to the circumstances and to the nature of the acts themselves by which the damage is done." Sound judgment itself dictates that in an action for falsehood producing damage to a man's trade, which in its very nature is intended or reasonably likely to produce, and which in the ordinary course of things does produce a general loss of business, as distinct from the loss of this or that known customer, evidence of such general decline of business is admissible. From this case, we learn that in cases of malicious falsehood, general damages not related to any specific customer or any specific transaction, can be awarded, provided that general damages are reasonably proven.